Okay, our third case on the list is number 2024 P1401, Kevin J. Shea versus City of Framingham. Yes.
Good morning. My name is Matthew Costa. I'm the attorney for the appellant Kevin Shea in this appeal from the Bristol County Superior Court. May it please the Court. So our contention in this case is that the Superior Court erred when it ruled, essentially, that the Framingham City Council could upend the balance of power that is envisioned by the Framingham City Charter in a manner that was severely detrimental to my client and effectively nullified his right to a 3-year appointment and a corresponding 3-year term of employment. My client was duly appointed to, Mr. Shea was duly appointed to the position of Director of Planning and Community Development, and I think this is a case that it's very closely tied to the terms of the Framingham City Charter. The division of, and so...
But what do we do with the fact that that 3-year term was not mentioned in the offer letter?
Well, I would cite two cases that basically state that the terms of law that pertain to a position of employment are incorporated by reference. And so when the mayor issued a letter to Mr. Shea offering the position of Director of Planning and Community Development position with the City of Framingham, that's a term that has meaning, and its meaning comes from the Framingham City Charter that everyone in Framingham is required to work under. So there's no other conceivable interpretation of that position other than it's defined in the City Charter as a 3-year term of employment as a department director.
Well, let me ask you the question that Judge Buckley asked you at argument, which is that what if your client decided halfway through the 3-year term that he got a better job somewhere else? Could he leave in the middle of the 3-year term?
He may be able to leave, and the city could potentially have recourse. That's something that happens frequently in this Commonwealth where someone has an employment contract with their employer. And it's a complicated question because we don't have indentured servitude, so we wouldn't expect an injunction saying, no, you need to continue working for the city. But Framingham would have a reasonable expectation that he would abide by the same term and meet the requirements of his appointment, which it's undisputed that that's what he was ready, willing, and able to do, and that's what the mayor was ready to continue to respect. And under the Framingham City Charter, it specified that only the mayor can remove department directors under a specified procedure.
So technically they did not remove him from his position. Is that fair? They just didn't fund the position, which...
That's correct.
So theoretically he could have stayed on there in that capacity just without remuneration.
I believe that's right. I believe that at the start of the new fiscal year, he may have been able to continue to go to work because there's no letter that revoked his appointment. But the problem is the charter contemplates that this is a paid position. It is a director of a department of a city.
Could he have sought a raise sometime in that 3-year period?
Well, the city council voted specifically to defund his position in particular.
No, but theoretically, we're saying this is the contract. Could he have, at year 2, say, this job is a lot harder than I thought it would be, or I think I'm providing more value. I think I should be paid $150,000. Could you give me a raise?
He could ask for that, and whether it's provided would be a matter of a decision for the city.
And then could the city then, on the other hand, say, we said it was $118,000, but we really think the job is worth more like $50,000 now, so we're going to reduce your salary to $50,000. Could they have done that?
They may have. That's kind of a hypothetical, but
right.
There's no reason a discussion like that couldn't happen. But
so why couldn't they reduce it to 0, which is essentially what they did?
So, because effectively what that means is that the balance of power between the mayor and the city council has been totally shifted. Right. The effective outcome of that is that the council's giving have the power to nullify the mayoral appointments.
Mayor had veto power on their defund, right?
That's right.
And the mayor chose not to exercise that veto power. Is that fair?
That is correct.
So doesn't that answer your balance of power issue on some level?
I don't think it does entirely. It doesn't, because the charter still has a specific procedure for removal from office. So say there was a veto and there's a budget battle. That still doesn't constitute the process for removing a city officer from their position. It wouldn't be the correct procedure. And I would say the Superior Court and the city, they've emphasized this opportunity of mandamus. But I would invite Your Honors, if you review the cases involving mandamus, they all seem to involve a situation where someone's trying title to their position. Perhaps someone's been appointed and there's an executive officer who's refusing to recognize their appointment. There's old cases when civil service came in where an executive, instead of following the civil service law, followed a different procedure, and they were the individuals were trying title against an executive. This case is different.
Can I say the subtext in all this, it seems to me, is that this was a targeted removal. In other words, they took him out because they didn't think he was doing a good job, your client, right?
Right.
Is that relevant to the judge's consideration or then to ours in this case?
It's not, because the charter specifies that the intent, and it's explicit, the intent is to vest all power over removal in the mayor. So when the council decides, okay, well, we're going to get around that by just singling out one specific position, and not just reducing a departmental budget, but to say that individual won't get paid next fiscal year, that clearly is a violation of the intent of the charter.
Let me ask you about the City Council's appropriation powers. It's interesting to me that this was happening in June of 2021. What if your client had been, say, the Director of Parks and Recreation, and the City Council said, okay, we've just gotten through COVID, we need to change our budget, we need to put more money toward the Department of Public Health and more money toward the schools, getting kids back into schools. We're not going to have Parks and Recreation for a while. Nobody's using that anyway. So we're going to shift our budget priorities around and put more money toward the schools. Can't they do that? You're saying they're locked into the 3-year terms?
The City Council has very broad discretion, and we're not arguing that doesn't. As a legislative body, and that's why we wouldn't expect the court to issue an injunction to make an appropriation, for example, because traditionally legislative bodies have discretion. And so in a situation such as that, sure, there could be a discussion about priorities within the city, but the thing that's unique about this position is it's named in the charter as a position that shall exist. It shall be appointed by the mayor. It shall oversee this department. There shall be a director of planning and economic development. So
well, they did fund the department, right?
That's
at
correct.
A more minimal level, so there was someone else there.
That's correct.
Even if it was only one person or two people, if there was something that needed to be sent to the director, I'm assuming that would be sent to one of those people.
But that person wouldn't have been appointed to this position defined in the charter. They might be an interim. They might call it something. But my client was appointed by the council. So when they made the appointment, they knew they were appointing someone for a 3-year term. They knew what the terms of the charter were. They knew there would be an expectation that this person would serve for 3 years, and they knew that the charter defines it as a position that shall exist. An option for the council in that situation, if they wanted to eliminate the position, they could amend the charter. There's a legal process to do that. But they didn't do any of that. They simply kind of overruled the mayor's power. The mayor made an appropriation request, too. So that signals that this wasn't a situation where the money wasn't available. The mayor submitted a budget. And the only explanation in the record is basically that the city council didn't like this person. The charter doesn't say that it's their role to decide whether or not they like the person. The person works under the mayor and can only be removed by the mayor.
Can you explain again, and I think you did, I just still struggling with it, why this is not a situation as the city claims of a writ of mandamus?
Because if a court ordered, so if the issue was presented as to whether Mr. Shea was the duly appointed Director of Planning and Economic Development, and the court issued the order, yes, he is. There still was no money to fund his position, so that would amount to him being like restored to a position with no funding. But when he took the job, he agreed with the mayor. He accepted her offer that it would be paid. And there's nothing in the charter that indicates that these departments...
And there was funding for the department, so I suppose they could have reallocated money toward him and then let some other folks go, theoretically, right?
I don't think so, because the budget order specified that this was an unpaid position. So I don't think the mayor has the power to like just ignore a budget order either. So there's this separation of powers. The mayor is supposed to be in charge of the appointees once they're under her direction, and the council does have authority over budgets. But they kind of took this to like the reductio ad absurdum level of saying, okay, well, we're going to take that and completely abuse it and nullify the mayor's power to make this appointment, nullify this individual's right to get paid. He left another well-paying job for this job.
It sounds like you're arguing the mayor's rights. And if the mayor had a problem with that, the mayor could have refused to sign, the mayor could have vetoed the budget, or the mayor could have sued, like in the Springfield case.
The mayor wouldn't have sued on behalf of my client, though. There is certainly the balance of power, but my client sort of, he is the one, to use a figure of speech, he's the one left holding the bag. He's the one that lost the job. That's assuming that the mayor, would care enough about city resources to engage in litigation. My client was just left, without a position, with no severance, nothing. Just at the end of an appropriation, 17 months left in his appointment. Terms of the charter that the city basically ignored or didn't follow. A letter from the mayor saying he would get paid $118,000 as an appropriate salary for this position, which he accepted. The city contends that there's no evidence of a contract, but the appointment letter dated November 3, 2019, it makes an offer. It states material terms. It asks my client to accept the offer. And so, it would... But
if we're going to read into that contract the part of the charter that says 3-year terms, then don't we also have to read into it the Article 6, Section 5D that gives the City Council broad authority to delete or decrease any programs or amounts?
Yes. But it says except expenditures required by law. And I think that's an important consideration here, because it's a fair reading of the charter that this department director position that shall exist, that shall oversee this department, that the council has no power to eliminate, because only the mayor can initiate a reorganization of departments. There's been no change in the charter, that it is an expenditure required by law. The city has to pay for a department of planning and economic development. It's in the charter. Otherwise, the city council is being allowed to eliminate something that it's been legally directed to retain. So this should have been viewed as an expenditure required by law. The city council should have said to itself, we have to fund this position because the city charter says that this position exists. But instead, they voted to eliminate the funding for it, which as a practical matter means that it doesn't exist, because these aren't positions that individuals volunteer for. That wouldn't reasonably be expected. It would be known that the practical outcome of that is that the person leaves their position, and that's what happens. And it wasn't done voluntarily. It wasn't done with the assent of the mayor. I don't think that's a fair interpretation. We have the affidavit from the mayor that says the job would have continued if the funding existed, and that Mr. Shea performed in a satisfactory manner. So this was an expenditure required by law. The charter has that language in it. There is so much discretion that legislatures have, but that shouldn't be deemed to nullify obligations of the city as a municipal corporation. Town meetings, city councils, they face this question all the time. There's some obligation. Sure, in theory they could vote no. In theory they could say we're not going to fund that. But what the Superior Court didn't address was that why wouldn't there still be consequences? What Framingham is arguing for is the ability to ignore its charter and not face consequences. And all my client is arguing for is that there are consequences, that if a position... I see my time is up.
Thank you.
Thank you.
Morning.
Good morning, Your Honors. May it please the Court. Catherine Fallon Manupelli on behalf of the appellee of the City of Framingham, asking this Court to affirm the decision of the Bristol County Superior Court granting summary judgment in favor of the City. And this is really the tale of two branches, the executive and the legislative branch. It's a classic checks and balances case here. The overriding issue before the Court is whether the trial court was correct that Mr. Shea's position wasn't immune from the City Council's appropriating authority. And the trial court was correct. The Council's action to defund Mr. Shea's position was allowed. It was a lawful exercise of their appropriating authority, and it rendered his subsequent breach of contract action untenable, legally untenable.
What does the language in Article 3, Section 3 mean about the 3-year terms?
The language denotes a term for the position, but it doesn't override every other provision under the law and under the charter. So the way that this is being construed is that somehow eliminates or abrogates the appropriating authority of the budget process, and it doesn't. It's the expectation that on the appointment the individual would serve a 3-year term, but it doesn't negate the requirement for that term to be annually appropriated.
It doesn't say subject to appropriations. It simply says 3-year term, right?
The charter provision does.
Yes,
Your Honor. And the letter.
So what if Mr. Shea had other job opportunities and he opted for this? He said, okay, here's a guaranteed 3 years. Here's where my family is at this point, and I have a 3-year job where I know what my salary is and I know at least I'm set. Is that an unreasonable expectation on his part?
It is not unreasonable, Your Honor, but it is not guaranteed. That language does not guarantee the individual appointed a 3-year term. It remains subject to the appropriation of the council annually. That is just. So
then, to Justice Grant's question, why even put it there? What's the point? Does it mean? I don't know. Leave the question. What's the point of having 3-year term in there? Whom does it benefit, or what is it?
It benefits, of course, for the continuity of the individual serving in the capacity. But again, it doesn't eliminate the ability for the council to remove the funding as a matter of appropriation process. So it benefits the city, but it doesn't mean that that's a contract with the city and that individual. And to the point of the question that was asked earlier, if that individual decided to leave in the middle of the term, the city wouldn't be pursuing a breach of contract claim against that individual. They would be looking to appoint someone to fulfill the balance of the term. And quite frankly, that happens a lot.
But could they? Could they say, well, you signed up for 3 years, and again, to the point, we don't have indentured servitude, but there are consequences, and if you leave before your term is up?
Absolutely not, Your Honor.
Okay.
Because this isn't a contract. It is not a contract between the city. The charter is not intended to be a contract between the city and the individuals appointed. There is no ability for the city to sue for breach of contract. Even in the cases that are referenced as supporting the position of a breach of contract, those are collective bargaining agreements. Those are statutes that create the right to an action in contract. The civil service cases that were cited by my brother, actually the law changed since then, but that the statute gives a certain termination process that's distinct from what we're talking about here. They don't support the conclusion that this was a contract and the city breached it, therefore he should be entitled to 3 years of appointment.
Is there an override mechanism in this city charter for a mayoral veto?
There is a veto, Your Honor.
So there's a veto, but then does the council have any authority to override the veto.
Yes, and I would actually say in the specific instance of the budget process, the mayor could object, but the mayor can't veto the budget appropriation. And to answer the questions that were laid out, the council can't go ahead and reshape who gets what. They can only reduce or remove funding. They're limited to that. And unless there's something missing in the budget that the mayor didn't put in there or propose, the council has an opportunity under the statute to go back and add it in under a certain process. But they can't take the budget and say, I don't want to do this anymore. We don't think this is a good division. We're going to eliminate the division. That's not how it functions under the law or under the charter. But they do have the right, reduce or remove, defund or decrease under the law and under the charter. And this is just well-settled municipal finance law. It is appropriate and it is acceptable to remove funding for a position, as the council did in this case. And the reason why the city is suggesting the writ of mandamus is the available remedy here, is it's not as though anyone in that same position where they're in a municipal position that's subject to funding, that the same exact process applies to every single one of us who's serving in a role with a designated term. Our position is subject to annual appropriation process, every single one of us. And the ability to challenge that for any type of wrongdoing would be through the mandamus, that's Chapter 249, Section 5 action. And that's why the city is saying he wasn't without a remedy here. He just didn't pursue that remedy, but the remedy that he pursued as a breach of contract is legally untenable. The mayor here has the power of the purse. She's the executive authority. She has the power of the purse to prepare the budget, to propose the budget, to persuade the council that every line item is necessary. But the council, as the legislative appropriating authority, has the power of the purse to say no. We don't think that that's the right amount. We're going to reduce the amount. We're going to defund the amount. This is straightforward statutory process under municipal finance. And it does happen, and it did happen in this case, but it didn't create a breach of contract just because in the charter another provision said that the expectation of the term was 3 years.
I'm sorry.
I know the city charter is fairly new.
Yes, Your Honor.
Do we know anything from the record, the affidavit of Mr. King or somewhere like that, where that language, who shall serve 3-year terms, comes from? Is it lifted from some other city's charter? Who serve sounds awfully mandatory.
Yes, Your Honor. Mr. King's affidavit is in the record appendix at page 325, and he actually was one of the drafters of the charter. And I don't think we specifically addressed that question, Your Honor. But there were stated terms, and there were some terms that were coterminous with the mayor. There were some terms that have a 2-year term, a 3-year term, and that it is a very new city, and that there were provisions on the transition through the process of transitioning from the town to the city. It was a very carefully drafted, and I'm sure that they evaluated. They had a consultant assist them with evaluating what other communities did in their charters. So I'd be guessing to tell you they probably looked at what those positions called for. Some positions have a different setup than this one in the charter. This one happens to be in the charter. But I don't think it matters in this case, Your Honor, what the stated term is, because fundamentally the trial court justice said it's subject to annual appropriation. The law says that. The charter says that. So we cannot eliminate or render it immune just because of that one provision in the charter. And this is just the heart of the case. The crux of the case is, was his position somehow immune from the appropriating authority of the council? And it isn't. None of ours are. And the fact of the matter is the trial court judge found that most of these facts are not disputed. The one that we're going back and forth on is the existence of a contract. And from the city's perspective, there's no change in the evidence that's been presented to this court that was presented in the trial court. There really is no difference in the view of that evidence. It wasn't intended as a contract. It doesn't say it's a contract. It doesn't reference the 3-year term. It references an annual salary. It doesn't even reference the charter provisions. And it also is quite clear that if Mr. Shea had left in the midst of a 3-year term, another individual would be a successor fulfilling the term. And what occurred in this case when the position was defunded, the individual who was the assistant stepped into the role. It wasn't an elimination of a department. It wasn't an elimination of a position. The council does not have that authority in the appropriation process. And to answer the question that was asked earlier, could in the midst of the service, Mr. Shea say, I need more money? There is a process under the law and under the charter for a supplemental appropriation. It follows the same process of the council deciding whether that's in the best interest of the city and whether that there's money to afford it. So again, this is just a clear balance of powers here. Because the council's appropriation authority doesn't shift anything in the mayor's appointing authority, I think that's just a misconstruction of the charter, Your Honors. The charter provision that allows the mayor the appointing authority unfettered, the removal authority unfettered, is really plain drafting that means that it doesn't have to go back to the council for approval. And it actually demonstrates that this is an at-will position. There's no hearing process. There's no time frame. There's just the requirement for the mayor to submit a letter and state, I'm removing this division head, and let the council know. There's nothing more than that. So in essence, it's just I think there's a misconstruction of some of these, and as Your Honors know, that there's deference given to how the city interprets it, and as the affidavit of Mr. King, who served in the town for years before it became a city and was one of the drafters of the council, that was the evidence before the trial judge.
Counsel, do you believe Justice Buckley found there was a contract?
I'm sorry, Your Honor, I didn't hear that.
Do you believe Judge Buckley found there was a contract?
I believe.
So do you believe that's error?
I do not believe she even addressed that, because she specifically stated even assuming that there was a contract. That Justice Buckley specifically stated even assuming the existence of a contract, it didn't negate the city council's appropriating authority. It negated an action in contract because they had the power under the charter and the law to do what they did.